Good afternoon. Good afternoon. My name is Dr. Neeru Gupta. I'm assistant professor in IIMT College of Law, and my topic is basic concept of law of evidence. Introduction. Evidence is derived from the Latin term evidere, which means to show clearly, to make plainly, certain, to ascertain, to prove. Taylor says the word evidence includes all legal means exclusively of mere arguments which tend to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation. According to Section 3 of Indian Evidence Act 1872, evidence means and includes oral and documentary evidence. Here, oral evidence refers to all the statements which the court permits to be made before it by the witness, and such evidence should be related to the matter of fact under inquiry. Whereas documentary or written evidence refers to all the electronic records presented before the court. Kinds of evidence: direct evidence, circumstantial evidence. Direct evidence is considered as imperative evidence for deciding the matter in issue. It directly proves or disproves the fact. In such evidence, a specific fact is established directly without providing a reason to connect or to the fact. One hardly needs to point out the illustrations provided as the evidence of the witness in court is direct evidence as opposed to a testimony to a fact suggesting guilt. Such evidence is real, tangible, or clear evidence of a fact that requires no thinking or consideration to prove its existence. However, relying on the evidence completely without any reasoning to prove its existence can be considered as a drawback as well. For instance, one may be prosecuted for perjury. Circumstantial evidence. Circumstantial or indirect evidence refers to evidence which prove the fact in issue or by providing other facts, that is indirect facts, and then proving their relevance. A satisfactory conclusion can be drawn from such evidence by relating a series of other facts to the facts in issue. Such indirect facts must have been associated with the facts in issue and have a cause and effect relation. Documentary evidence. According to Section 3 of Indian Evidence Act, documentary evidence means to any matter described or expressed upon any substance by means of letter, figures, or marks, or by more than one means, which can be used for recording the matter. Such evidence is proved Such evidence is produced in the form of a document in order to prove a disputed fact. Essentials or subject matters of documentary evidence are as follows: how the content of a document are to be proved, how the document is to be proved to be genuine, how for and in what cases the oral evidence is excluded by documentary evidence. Hearsay evidence. Hearsay evidence refers to evidence which the witness has neither personally seen nor heard. It is just reported by the witness and considered to be very weak. In other words, it refers to something that others have said or heard. There are no set standards to receive such evidence provided it has reasonably credibility and nexus. In the absence of such credibility and nexus, it is difficult and dangerous to act upon such evidence. Thus, such a piece of evidence cannot be used if its credibility is not assured and questioned. The necessity of rule of evidence. The other one is, if there are no rule at all, then no case will be ever decided. It would take years before the simplest case is decided and justice would become a monarchy. Further, if you leave it to the court to decide on each occasion what matter are connected with the matter in controversy and therefore should be looked into by the court, there will be great uncertainty as to relevant matters depending upon the patience of the judge. Therefore, the rule of evidence are absolutely necessary both from point of view of time as well as certainty. Law of evidence as a part of procedure law. We have gone through the point that rule of evidence are necessary. We have also seen they play an important part in the course of trial. whether of a civil or a criminal case. Since it deals with the procedure, it is under the category of law referred as to procedure law and adjective. In contrast to substantive law, which deals with rights and liabilities, under what conditions a certain right exists in a certain person, under what condition is a person subjected to a specific liability. Law of evidence is a part of procedural law. The law of evidence, however, is a part of procedural law, the procedure which a court has to follow. It said that the law of evidence is in the law form or lex fori. It is a matter of convenience, which means in the evidential procedure, the court must follow those procedure of the country of the court. The foreigners cannot insist upon their law of evidence being followed by their countries. Functions of evidence law. The law of evidence is of great importance to judicial proceeding before below are some of its functions. Number one, it prescribes the manner in which relevant facts may be objected in a court, either by way of oral or direct evidence, or admissible hearsay evidence, or judicial notice, presumption, or documentary evidence, etc. The law of evidence determines what fact may or may not be proved in a court of law. It does this by excluding those facts which not be proved. The law of evidence elaborately lays down the competence or privilege of witness. It stipulates rule on who qualifies to be a witness and who does not. It determines the question to be asked to the witness and the manner of doing the same. The law of evidence also sets down the manner of proof in court by witness on oath subject to examination in chief, cross examination, and or judicial notice, presumption, admission by production of material object or documents. There are certain basic technical terms used in the law of evidence. The meaning of some of the terms can be easily understood from the use of ordinary language. Others are slightly technical. What follows below in a definition of some of the most crucial terms which are applicable in the day-to-day application of the law of evidence. The list of certainty not exhaustive. Fact Facts means anything, state of thing, relation of thing capable of being perceived by the sense, and any mental condition of which any person is concise. Fact in issue. A fact in issue means any fact from which, either by itself or in connection with other facts, the existence, non existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows thereof. A fact in issue may be a fact that one party alleges and the other party controverts. Relevant factor. A fact is relevant if it has a probative value, that is, if it tends to persuade a court of law of the probability or possibility of alleged facts. Evidence is said to be relevant to a case if it has a direct connection to the facts in issue and can be used to prove or disprove that fact. Prima facie evidence. It is a kind of evidence which normally necessitates a finding that a fact has been proved if such evidence is not rebutted. Direct and indirect evidence is that means of proof which stands to show the existence of a fact in question without the intervention of the proof of any other fact, and it distinguished from circumstantial evidence, which is often called indirect. Indirect evidence, on the other hand, refers to circumstantial evidence or evidence of relevant facts which have already discussed above. Oral evidence, there are statements made by a witness in court. It refers to a person, testimony offered to prove the truth of the matter asserted. In probable evidence, this refers to extrinsic evidence and is at times referred to as a parole evidence rule. This rule stipulates that no intrinsic evidence shall be admissible to add or to subtract from the content of a written document. Primary and secondary evidence. Primary evidence is also referred to the best evidence. It is evidence of the highest quality available as measured by the nature of the case rather than the thing being offered as evidence. For example, in documentary evidence, if the original document is available, it must be offered rather than a copy of the original document. Secondary evidence, which is inferior to primary, thus a copy of an instrument or oral evidence of its content is secondary evidence of the instrument and contents. Opinion evidence. This is where a witness is called to testify as to his or her belief, thought, interference, or condition concerning a fact or facts. It is a conclusion formed from observable phenomena and mental impressions proved. A fact is considered to be proved when the court, after considering all the evidence after the trial and proceedings, either believes the happening of the case in such a manner as it is expressed, or if the court makes a probable interference belong to reasonable doubt and believes that the existence of the case in such a manner as it was explained disproved. A fact is considered to be disproved when the court, after considering all the evidence after the trial and proceedings, either believes that it does not exist as explained, or if the court makes a probable interference beyond reasonable doubt and does not believe the existence of case in such a manner as it was explained not proved. A fact is called not proved when the facts are in circumstantial condition that they are neither proved nor they are disproved. Presumption. Presumption generally means a process of ascertaining few facts on the basis of possibility, or it is consequence of such acts in general which strain the possibility, and when such possibility has great substantiate value, then generally facts can be ascertained. A presumption in law means interference which are concluded by the court with respect to the existence of certain facts. The interference can either by affirmative or negative drawn from circumstances by using a process of best probable reasoning of such circumstances. The basic rule of presumption is when one fact of the case or circumstantial are considered as primary facts, and if they are proving the other facts relating to it, then the facts can be presumed as if they are proved until disproved. Section 114 of Indian Evidence Act specifically deal with the concept that the court may presume the existence of any fact which it thinks likely to have happened, regards being had to the common course, a natural event, human conduct, public and private business in their relation to the facts of the particular case. May presume. It is a condition when the court enjoys discretion power to presume any certain few facts and recognize it either proved, or may ask for corroborating evidence to confirm or reconfirm the presumption set by the court in its discretion. Section 4 of Indian Evidence Act provides that a fact or a group of facts may be regarded as proved until and unless they are disproved. The concept is defined under Section 4 of this Act that may presume deals with rebuttable presumption and is not a branch of jurisprudence. Shall presume. It denotes a strong assertion or intention to determine any fact. Section 4 of Indian Evidence Act explains the principle of shall presume that the court does not have any discretionary power in the course of presumption of shall presume. Rather, the court has presumed facts or groups of facts and regards them as if they are proved until they are disproved by other party. Section 4 of Indian Evidence Act explains that the concept of shall presume may also be called presumption of law or artificial presumption or obligatory presumption and rebuttable presumption of law. Conclusive presumption, it can be considered as one of the strongest presumption of a court may assume, but at the same time the presumption are not completely based on logic. Rather, court believes that such presumption are all for the welfare of the society. With regards to conclusive proofs, the law has absolute power and shall not allow any proof contrary to the presumption, which means if the fact presumed under conclusive proof cannot be challenged, if even if the presumption is challenged on the basis of probative evidence. This is the strongest kind of all the existing presumption, whereas section 41, 112 and 113 of Indian Evidence Act and section 82 are one of the most important provisions relating to the irrebuttable form of presumption and conclusive presumption. Relevancy of fact, doctrine of res gestae. The doctrine of res gestae is expressed under Section 6 of Indian Evidence Act 1872. Essential of doctrine of res gestae. The statement made should not be an opinion and must be a statement. The statement should not be made by the participants of the transaction. The statement should have enough information to explain or brief about the incident. The statement made by the person or the act of person should be stimulates to the main transaction. A leading case, Ratan versus Kuhn. In this case, the victim called the police for the help as her husband was holding the gun and was about to kill her. But before the operator could get connecting to the call and report the statement of the victim, the call disconnected. Later, the police found her dead body in her house, from where she called the police for help. Later, the police found that the time of the call and time of death was almost the same. So, the call by the victim comes under the principle of res gestae. Hence, the court found the husband guilty of murder and questioned his reasoning that he shot accidentally without any intention. Uttam Singh versus State of Madhya Pradesh. In this case, the child and the victim were sleeping together at the time of the incident, and he suddenly awaked due to the voice of X and screamed for help by taking the name of the accused. Just after the call for help, his mother, sister, and other witnesses come there. The court found this evidence to be admissible as to the act the child and the accused was of the same part of a same transaction. Next, motive, preparation, and conduct. According to Section 8 of Indian Evidence Act, talks about the importance of motive, preparation, conduct in various cases. Conspiracy. Conspiracy means few people come together to do an act with common intentions. So, in the same context, a criminal conspiracy is the act of at least two or more persons to do an act which is not authorized by the law, an illegal act, or to do a legal act by illegal means. Criminal conspiracy is a kind of partnership in crime, and every member of such partnership must join the partnership by mutual agreement for executing a common plan. Essentials of criminal conspiracy under Section 10 of Indian Evidence Law. There should be reasonable ground to establish a conspiracy. There should be at least two or more persons to form a conspiracy. There should be a common intention. The act or statement of the conspirator must be in reference to common intention. In this case, the court in its judgment showed that anything which is doubtful cannot be considered as legal proof, and such proof are insufficient to prove any criminal conspiracy. Next, alibi. The word alibi is derived from the Latin word which means elsewhere. Section 11 of Indian Evidence Acts explain the concept fact that facts not otherwise relevant become relevant and makes the provision as a defending ground of the accused. The simplest meaning of this section is a condition when the incident took place and the accused is charged for the incident, then he may make defend him on explaining that at the time of the incident he was not present at the location.